Hi, students. We're going to continue our lecture on drafting the memo. We've already talked about CREAC. We are going to now start highlighting part of the most important part of CREAC, today focusing on the rule explanation section. We're going to do the rule application in a separate recording. So, why do we have a rule explanation section to begin with? I mean, we have a rule section, right? CREAC is conclusion, is C, R is rule. Why is there an E for rule explanation? Well, in the rule or the R, you're just saying what the rule is generally. The rule explanation is an opportunity to give you an example of what the rule looks like, because a rule in the abstract can be or seem very different when it impacts with real cases. This is your opportunity to give an example of how the law has applied in the past. It goes all the way back to stare decisis, right? So you're going to, if you say the sky is blue, you're going to now offer up examples showing that, in fact, the sky is blue. You do this by fully explaining, you do this by fully going through the facts, the holding, and reasoning of relevant cases. So for every case that you discuss, these are some things that need to be highlighted. The issue you're using the case to illustrate, that needs to be put out there right away, because that's an important point of context to your reader. Don't throw your reader into facts, but let them know what you're using the case to illustrate. How was the issue resolved? Have you provided enough legally significant facts? Remember, I didn't say random facts, right? Or, interesting facts, but legally significant, also known as outcome determinative facts, to show how the court applied the law to reach its holding, why or how the case is analogous, or if you decide to distinguish it, distinguishable. But you're not going to do any analysis yet. You're just setting the facts up because the analysis is going to come later. You also need to identify the reasoning by the court. That way the reader can understand why the court ruled the way it did. Summarize important information about the case. Try not to include irrelevant details. I've had students who have tried to draft rule explanation sections on a single case for 2 pages. That's too long, right? Instead, I want you to think of yourself as having a surgeon's scalpel and taking that part of the facts, the holding, and the reasoning that relates to the point that you're trying to make at that moment. And if you want to use the case again for a different point, then do the same thing. You should have a topic sentence to let the attorney or your reader know why the case is important. And you need to, in that discussion of that case, highlight any factors or anchors that are important. This is not the time for your personal commentary. There should not be any sentences in your rule explanation paragraph that say something like, obviously the court was most concerned. Well, that sounds like you're commenting. The star of the rule explanation section is the court. Make sure you're making the court the star. The facts they considered, their holding, their reasoning. Now, both the rule explanation and rule application, even though I say paragraph sometimes or sections, this can be multiple paragraphs. So don't think you're only allowed to have one paragraph. Even though CREAC is a wonderful formula for us to follow, it's not so rigid where if you did a rule explanation, you have no choice but to do an application. You're going to let the law help you organize your analysis as well. When you think about the rule explanation, think of it in 2 parts, stating it and explaining it. The goals are to explain only that part of the rule that applies to that issue you're addressing. Think about your doctrinal courses for just a moment. When you're studying something in one of your doctrinal courses, you don't just study an entire section at one time, right? You study subparts of a particular rule. I want you to take that same approach with your rule explanation. You are highlighting that part of the case that highlights that sub-rule, not talking about the entire case. Your goal is to try to illustrate any anchors or factors. Remember, as those terms are interchangeable, that only refers to flexible considerations by the court to determine whether or not an element is satisfied. You need to make sure you understand the big picture. Also, keep in mind, the law is rarely ever defined on a single case. So try to avoid just having just one case and that being the end of your rule explanation. Your rule explanation should help validate your conclusion because it's going to help the reader believe that the rule is what you said it was. But to do that, you have to give them enough information to understand the rule. It also will help you educate your reader and it will support your analysis. So to understand how the rule applies to your facts, the reader has to understand how the rule has applied to similar facts. Explain the purpose, policies, past application. Again, not everything about the rule. You're going to limit it to information that pertains to your client. So here are the three primary components of a rule explanation section: a thesis or topic sentence, legally relevant facts of the case, and the court's rationale or holding. Trying to shove all of this in a single sentence or two also usually does not work well. You need to give enough information about the case so the partner or the judge or whoever's reading it doesn't have to do their own research just to figure out what happened in the case. It's almost like Goldilocks. You have to find the just right amount of information. Let's start with the topic sentence. The whole point of the topic sentence is to serve as a roadmap, to orient the reader and to provide context. Basically, why are you using this case? What point or legal idea are you trying to use this case to illustrate? Here is an example. The proximity of the structure to the primary residence is also a relevant factor. In McIntyre, for example. Now, before I see anything about McIntyre, I know, because you have clued me in, that I need to be focusing on the proximity of the structure. You told me so in the first sentence. And the next example, in the cases in which the courts have held that the plaintiff consented to the interception, the defendant had told the plaintiff that all of his or her phone calls would be intercepted. For example, here, once again, I already know what this case is about without even getting into the case. That is the power of a good topic sentence. Next, you need to illustrate those anchors or factors. Everything after your topic sentence should include the facts, the holding, and the reasoning in that order from cases that explain or illustrate the topic, anchor, or factors you identified in your topic sentence. And those factors or anchors, you also would have identified them in your thesis paragraph just previously. Second component, the facts. Select the facts that relate to the particular factor and give only as much information as necessary to understand the court's holding. For example, in McIntyre, the owners used a screened porch for sitting, eating, and cooking. They ate their meals on the porch in the summer and cooked meals there during the winter. This isn't telling me everything that happened in the case, but they're trying to have that laser focus and just focus on what's legally significant to that issue at hand. And then the rationale or holding. Give only the part of the holding or rationale that relates to that particular factor. The court held that the porch was a living quarters under the statute, reasoning that the owner's use of the porch for sitting, eating, and cooking made it part of the living quarters of their home. How do people struggle with the rule explanation? Because this is actually one of the easier parts of the memo because you guys have had a little bit of practice with briefing your cases. You're really just summarizing precedent in this section, but I'm trying to make sure you have the right structure. So one common mistake in this section is when students try to prematurely go into analysis. The rule explanation section is not the time for analysis. It's not the time where you should be mentioning, alluding to, or saying anything about the client. The star of the rule explanation is the court and precedent. That's it. Don't discuss client facts in the rule explanation section. That does bear repeating. Focus on the rule itself. The analysis will come later. You've got plenty of time to do your analysis. How do you choose cases? You want cases that best illustrate the rule or factor. Seminal cases, and when I say seminal case, I'm talking about the case that kind of set the standard, right? Seminal cases may be helpful in citing the general rule, but they may not be so helpful in explaining the rule. So make sure you choose wisely. For your very first memo assignment, it's going to be a closed research problem. So I or your professor will be choosing the cases for you. Here is an example of a poor rule explanation. In United Pacific Insurance versus Discount Company, the court held that a defendant obviously attempted to evade service when she slammed the house door in the face of a process server holding a summons. In that case, the process server had told the defendant that he had some legal papers to deliver. Surely this simple statement would serve to convey to the defendant the general nature of the process server's presence. Let's talk about why this is not a good rule explanation. We can start with the very first sentence. The first sentence should be a topic sentence to let the reader know what factor or anchor you're trying to illustrate or what the paragraph is all about. Instead, this particular author decided to start with the holding. Let me see if I can get my little pointer. The court held. Well, it doesn't make sense to jump into the holding before you have context with the facts. So it's just not helpful. So don't start with the court held this. I'm not sure about, obviously, maybe that was in the case, but it sounds like hyperbole to me. Now, after they said the holding, then they're going to the facts, which is also kind of out of order because once I read the facts, I may have to go back to figure out what the court held. Here, this writer wrote, in that case, the process server had told the defendant that he had some legal papers to deliver. Surely this simple statement would serve to convey to the defendant the general nature of the process server's presence. Says who? This sounds like personal commentary. Surely? Is that what the court said? Simple statement. This just all sounds like the writer's commentary. And if it's your personal commentary, take it out. No one's interested in your personal commentary. Instead, they should have highlighted the court's reasoning. The court noted, the court concluded that the statement provided served to convey blah, blah, blah. That would have been a much better decision. Here is a better example of a rule explanation. The first factor in determining whether a defendant was personally served is to establish whether the summons was physically given to the defendant. Let me stop there for a moment. Remember I said you should start with a topic sentence? That's exactly what they did. They have a topic sentence that highlights one of the factors or considerations by the court. The first factor is if whether or not the summons was physically given to the defendant. Before I read anything else, I already know what to look out for in the case. In Weiss, a process server attempted to deliver legal documents to the defendant at a location the defendant was currently staying at. While waiting outside, the server saw the defendant through a window. He held the documents up, yelled to the defendant that he had been served, and placed the documents on a windowsill. That is sufficient legally significant facts for me to understand what happened. Unlike the case before where I really don't know what happened. After the facts, they go into the holding. The court held placing the documents on the windowsill failed to comply with the summons statute. The court reasoned that the service failed because an essential element of the statute is that the documents are left with the defendant or a suitable person, not a substitute place. Why is this a good rule explanation? Well, first, it checked off all of the boxes. Second, it's very clear. You understand exactly what happened in the case. It's easy to follow. So work on, it doesn't have to be exactly like this, but work on making sure that you check off those boxes and that you develop your rule explanation. It shouldn't be so short that your reader has no idea what's going on or what the case is about. So that concludes our brief lecture on the rule explanation section, and we will talk more about the rule application section during our next recording.